Welcome back to the Law Unscripted, where we talk about all the things about the law and the legal system that you never knew, you never understood, and no one ever told you. I'm Virginia Tehrani, and I will be joined by Chelsey Rogers. We're with Tehrani Law, LLC, because you never need a lawyer till you do. And this week, Chelsey sure needs one. We are picking up part 3 of our series of the stages of a criminal case, taking you through arrest all the way to trial. The first part, we talked about simple traffic citations, and hypothetically, we had Chelsey getting charged with a misdemeanor. Stage 2, part 2, that we covered last week, we had her pick up a felony charge, and now she is in jail waiting trial. We left you last week after she had done preliminary hearing and was waiting for her circuit court trial, and that's where we're going to pick up again this week. So stay tuned while we walk through the rest of our hypothetical where Chelsey goes to trial.
Okay, I like it. So after that, now we are completely in circuit court, and we are just sort of pending a trial.
Yes.
So at this point, had I not been able to bond out, I would have been being detained.
You're
I would
still
have been
there.
in jail this entire time. Pre-trial detention is wild.
Yeah.
Okay, so now we have done our hearings. We don't have anything else except the trial, right?
Pretty much, but there can be other motions. So you could do a motion to reconsider bond.
Right.
That can be done before the preliminary hearing, at the preliminary hearing, or even in circuit court where you have a whole nother judge, right? So you're going to make another motion for reconsideration of bond, to reduce bond, to change bond.
Yeah.
The defense is going to have to produce different evidence, though. Okay. Some kind of evidence to show that it should be reconsidered. Have they found a family member who will step up and say, you know what, they have an address with me. Mm-hmm. They can stay with me. They have a local address, so they're less of a flight risk now.
Right.
Oh, okay, we'll give you a secured bond.
So it changes it a little bit, right?
We'll reduce it to this. Some kind of different evidence. It usually requires witnesses for reconsideration of bond. But that is one motion that can be made in the meantime.
And there's also could be some negotiations, right? We talked about it with a couple different things. You know, whether you're charge bargaining to say, all right, can we get these down to a couple misdemeanors instead of a felony? Oop, the puppies are so excited. So maybe there's that. But it could also be, you know, we can agree to a plea deal. Or if we're talking about drugs, I had a baggie of heroin and a needle, but I'll tell you who I got it from.
There's absolutely that plea bargaining. So it is really a big time for plea bargaining. Did we get it past, there's a waive preliminary hearing, so we have better plea negotiations, or we already have one. The trial date is set usually for these things if you already have an agreement worked out.
Yeah.
When you get to the felony circuit court placement, they'll set different trial dates or different dates for plea dates versus trial dates.
Okay.
And the plea dates will usually be quicker, faster. You can waive speedy trial.
Right.
That will be another bargaining tip bargaining tool by the prosecutor is if you waive speedy trial, I'll give you this. So they're not worried about how quickly they have to put on a trial. That's a bargaining chip. You can talk about differences of misdemeanor, how much probation time, can you give a year versus 2 years of probation? Right. There's so many options that you can use, especially depending on your jurisdiction. There are going to be more common plea negotiation tactics and options than others in each and every jurisdiction. From one county to another county, they're going to be different. One county is going to say, you know what, I'll argue for fewer jail years, but longer probation, where another county is going to give you shorter probation, but longer jail time. So you really need to have someone who is familiar with the jurisdiction to know what are the common negotiating factors in that jurisdiction. You can always do something different. You can always try for something different. Think outside of the box. Look at your individual defendant in case.
And your own calculus might be different, right? Like in our hypothetical, if I had been, we talked about it in the beginning, if I had been pulled over in Maryland, the ultimate stakes are not as high.
Still a misdemeanor.
It's still
You're not even going to circuit court in Maryland.
Right.
You're going to trial in district court.
As a defendant, and this is my personality too, I'd be much more likely to roll the dice at trial in Maryland than I would in Virginia. Even if, say, it was completely innocent, this was something. And there you see sort of the power of plea bargaining is that, say, it was a neighbor's car I borrowed, completely sort of innocent of that. In Maryland, I might say, take it to trial and make them prove it. But in Virginia, I don't know if I would do that. I might take a plea to something lower.
Yeah. All these considerations.
And you can plea all the way sort of from the moment you're sort of arraigned up until the whole process.
Yeah, you can even plead in the middle of trial. We've seen that nationally. We've seen several. They'll start with a trial in front of a jury trial, and then you take a recess, and the next thing you know, the defendant's like, you know what, I'm pleading guilty.
Yeah.
Because they don't want to, the jury trial isn't going so well. They see this, now they get scared. Yeah. There was one famous example. I really wish I could remember what it was. One famous example where the mother goes to talk to him in the middle of the trial.
Oh.
And all of a sudden she had convinced him to plead be responsible, do the right thing. I know you did it. You know you did it. And all of a sudden they go back in and he pleads guilty.
That's
I wish I could remember which one.
Know.
I also watch a lot of true crime. I watch so much TV true crime. I am all about Joe Kenda Homicide Hunter, Forensic Files. I've been on Homicide City, Murder Comes to Town. I mean, you name it, I watch it.
I like 48 Hours a lot.
ID, the 2020. There are all of these things. I cannot watch the family ones, though, where it's like evil siblings, children who kill, that stuff. I can't do that. It feels like it's a little more real.
Those are scary.
Possible. Like, not that I have family members that I think would do me in, but you just, you're sleeping next to your spouse and you start watching these spouse murders and you feel, like, maybe I should scooch over a little farther away. Do I know what they're thinking? Should I sleep downstairs? I just...
Right? No, I mean...
The questions are higher.
Right? It's like... I saw somebody do this, and I'm sure it's been done a lot, but I recently saw it on TikTok, my addiction. No. It was a maid of honor speech, and she said, congrats, you're now sitting next to the person who's statistically most likely to kill you.
Oh, no! In her speech?
It was so funny. I'm sorry. Like, that's my type of humor.
That's hilarious.
She said it, it was her sister as the maid of honor, and she stood up and said it, and I died laughing because...
that's so funny.
The husband did it, right? Like, that is the trope.
Oh, that's so funny. And it's true.
Yeah.
It's so true. But yeah, during your wedding...
I don't know. I thought it was
that's
so...
funny.
Like, you just saw everyone die laughing. And it was really well done. I thought it was funny. I'm sure some people would not have been amused.
Right. This was very poor taste.
Yeah, I thought it was funny, but...
That's great stuff.
Okay, so I have not pled to my charges.
Yep.
I said take it to trial. That's my personality.
Yep.
Prove it.
Go for it.
And look, sometimes you win, sometimes you lose, but... that's who you are as a person. Are you going to roll the dice? Mm-hmm. I am. I'm going to say...
It's great.
The Commonwealth of Virginia, prove it. So we get up there, and I say, I want a jury trial. I don't think you
go for it.
Demand a jury trial.
No, you do. You have to demand a jury trial.
I was going to say, I didn't know if it was automatic in circuit, but...
You have to demand it. Okay. You have to request it.
Yes.
You have to do a jury request. And in Virginia, the Commonwealth can force you to a jury.
Oh, I love that. Oh, I love that. I think juries...
Or at least when I was there, I'm trying to think, the last year I prosecuted was 2015. So it's been 8 years. And I honestly don't know. I think that is still the case.
I would assume so.
I think so, but I know that when I was prosecuting, I had the right as the Commonwealth to actually force a jury trial.
Okay. So
I'm going to say it very often.
I'm going to say my personality, this is how it would go. I'm going to choose it. I'm going to say, give me a jury, prove your case.
And speedy trial.
I want to see it. Let's go. Mm-hmm. And this is where, and I'm hoping we'll talk about this on the Weekly Wine, maybe coming up. The defense doesn't have to do anything, right?
That's right.
The only person who has a burden at this trial is the state, is the Commonwealth of Virginia in this case, right?
In this case, yes. It's not a self-defense case where you would also have a burden, but generally, unless it's that rare case, the Commonwealth, the prosecutor, is the only one who has a burden.
And so, again, theoretically, more than sort of in practice, that the defense, is there to cross-examine, but technically they don't have to put up any of their own witnesses. They don't have to do anything. Most commonly they're going to, but they, theoretically don't have to. And this is the hot topic that I am fascinated by, and I know myself, so I would not be taking the stand because I say everything that comes into my head, for better or worse.
Sometimes I would advise you not to take the stand.
And I think that's the...
Chelsey Rogers, please don't take the stand. Some people can, but not you.
And I agree. That's the thing, is that for better or worse, any thought that comes in my brain comes directly out of my mouth, and I can't shut up to save my life. So very bad on the stand.
I would cry as a defense attorney if you took the stand. During your testimony, I would cry, or I'd be like, Judge, I have to take a break.
Yeah.
And I'd sit there
and have withdraw as counsel?
Myself. Can we start over?
I think that's the truth. And I think sort of the overwhelming advice is don't put your client on the stand, but if you are the defendant and you
can choose,
I can say, I don't care what your advice is. Put me up there.
Yes.
And then you have the interesting job as the attorney, knowing this is a bad idea, to then have to direct me.
Still have to.
And you don't know what is going to come out of my mouth. We're not even on the stand. We're across from each other. You don't know what I'm going to say.
Yeah, right. I know. It's unscripted because it's Chelsey. We can't pre-script this stuff. It just...
No.
Things that she comes up with, it's just random.
But it really is. But some people say it is my right as a defendant to tell my side of the story. Which we talked about it sort of with our self-defense, is that to me makes the most sense in a case like that. And maybe you say in this scenario, it is worth it to put me up there saying, I was speeding. I was on the way to a job interview. Mm-hmm. I borrowed my neighbor's car. Yeah. And you keep the direct very limited.
As limited as possible,
You know, sort of to those facts of it was an emergency. I borrowed a neighbor's car. I don't know them that well. Mm-hmm. And I assumed everyone keeps their registration in the glove box, and I opened it.
Pulled it out,
And I had no idea, right? That's where you sort of have that.
Yes.
But the state can't make you take the stand.
No, they cannot. It is a defendant's right not to testify against himself.
Which I think is fun. That, wouldn't that be easy? You have somebody like me.
You can't talk about it. It is such a solid constitutional right not to take the stand that as a prosecutor, I cannot comment on it. And I cannot say...
You can infer that they're guilty.
Right. She must be guilty because she decided not to testify. She didn't even get up and tell her own story in front of you. I cannot say any of that. I can't. I cannot comment on the fact that you did not testify. If you did testify, I can comment on what you said.
Right.
But if you don't, I cannot tell the jury anything about you not testifying.
Yeah.
Now, as a defense attorney, if you choose to testify, my two things that I would do...
I would love to see this. We should do a mock trial and I'll be the witness.
We totally should, and we can. My strategy would be twofold.
Yeah.
Is I would start off your direct examination saying, do you understand, Ms. Rogers, that you don't have to take the stand?
Of course.
That it's your fundamental constitutional right that you don't have to.
Yeah, I just want to tell my story.
Are you choosing of your own free will to come and tell the jury what's happened?
Absolutely.
I'd start off that way.
Yeah.
That way the jury's like, oh, but she wants to.
Yeah.
We need to
That's
hear
true.
what
That's very,
she says.
It's humanizing.
It's very humanizing. It feels like you're doing something.
Yeah.
It puts you in a more positive light to start out with. Some judges won't let you do that. Depends on your jurisdiction. But if your jurisdiction will let you do that, I would recommend it. My strategy would be to do that. Then at the closing argument, I would say Miss Rogers got up and told you her story. She didn't have to.
Right.
She is not required. The Constitution gives her a fundamental right not to do that.
And she did it anyways.
She chose to do it because she wanted you to hear what has happened.
From her, right. And then you also just try to make me look. I laugh when you see these sort of in some of the true crime cases that are really famous, the transformations of people, what they look like before they come into the courtroom. That is a new person. That is
Yeah.
like Betty who teaches Sunday school. Who is that?
Yes,
But
I'm going to let you borrow a dress and some shoes. And that's, I'm going to have a closet.
Relatable and credible, which, again, the truth is you can't tell someone's trustworthiness by the way they look, but we are humans and we do have that unconscious bias. And as a good attorney, you play to it. You can't beat it. Everyone is going to have some sort of, it's like, your human nature. So what do? Like, if you can't beat them, join them, and you capitalize on it, right? And that's when
tattoos,
you have,
I'm going to try to cover them up.
Absolutely. You have all these like piercings.
We're going to take them out.
Yes.
You have funky hair. We're going to try to, put it down.
Yes.
We're going to try to make you look as
innocent,
normal, innocent, plain Jane as possible.
Yes.
As nice, like you said, Sunday school teacher, that's what we're going to do. If I can put you in a dress, I'm going to put you in a dress.
Mm-hmm.
I'm going to put you in colors that are more neutral.
Yeah.
I don't want you
bright red.
I don't want you wearing a marijuana shirt. There are things that I want you not to wear. Public defenders' offices will often have a closet that they use where they're going to pull out some clothing that they keep for having their defendants wear. They'll dry clean it, wash it, that sort of thing. But they'll have some kind of closet that they can go to for outfits.
And then you'd have to prep me for cross. Can you imagine that, Virginia?
Yeah. Because if you take the stand as a defendant, as a witness, as any witness, you have the right to be cross-examined. And you cannot put the defendant up and not be cross-examined. Right. So that is the risk. I put you up on the stand. Yeah. I can talk to you. I can ask you questions, but so can the prosecutor.
Yeah.
And that's where a lot of things go south.
Yeah. I think that's true. Is that, for people who truly and earnestly maybe are innocent and this has really escalated, they do want to tell their stories. I think that sort of what I've seen in this wrongful convictions class is the people who truly are innocent have this innate desire to, if I can just tell the truth, people would just hear my side of this story, then we can take care of all of this, right? And it gets them into trouble.
Sometimes they don't tell it well.
And then they get flustered or angry.
Upset. Yeah.
Because that's sort of, right, if you have a defendant doing that and then you're the prosecutor, you're going to come and ruffle their feathers in the way you ask questions. That's what you're trying to do. Because if you can get them, the more they say, it's like giving them enough rope to hang themselves with.
That's exactly the theory.
And it's harder if that on cross, you just say yes, no. Yeah, like
you look bad.
Right. And that's another part of it is that
about appearances.
When you have a jury now, hey, if it's a judge, I might just say yes or no on cross and keep it moving.
Because the judge knows.
Yeah.
And that's the question. Do you choose a bench trial instead? Are you actually more likely to be found not guilty with the judge than with the jury?
So maybe in our hypo, they have found me guilty. Unfortunately, they didn't believe me. So what happens next?
You go to sentencing. You usually have the same jury who did the original charges and conviction will usually do your sentencing. Not always. Depends on your jurisdiction. But usually they go into sentencing.
And so with sentencing, I know obviously every jurisdiction is going to be slightly different in sort of what the rules are, but they usually give you a range, right, of like the possible or the normal ranges for this. I mean, I'm sure in some cases they go outside of it.
Well, they're told. Yeah. The jury is told this is, the class 5 felony.
Yeah.
She, under the law, has to have 1 to 10 years. Mm-hmm. That's the penalty.
Yeah.
You as the jury have to decide between 1 to 10 years.
Yeah.
Any range between this. As a prosecutor, depending on your facts, I'm going to give the jury what I think you should.
Yeah, sort of make arguments about that.
I think you cannot say that any of the time is suspended in front of a jury.
Oh.
It is 1 to 10 years. So
that's the judge's call then. Mm-hmm. Okay, so the jury could come back, we'll just meet in the middle. They say, yeah, we didn't believe it. You're guilty. We recommend 5 years.
Correct.
And the judge could say, yeah, I don't know how I feel about that. I've also heard all of the evidence, and I'm going to accept the jury's recommendation of 5 years, but it's a suspended sentence, right?
Correct.
Okay.
He can suspend any or all of that time. The jury can't, but the judge can.
Have you ever seen it that dramatic where, the jury recommends 5 years and the judge says I'm just going to suspend all of it. That feels really dramatic to me.
Yes, it is dramatic. It really can be.
Yeah.
It's, as a prosecutor, I loved when the judge just accepted whatever I said and whatever the jury recommended. But the judge does like to have some suspended time because of probation, where if they put you on probation, that's like trying to keep you out of trouble so you don't serve the rest of your time. Yeah. So there's something holding over your head. But technically you can send you to jail for the full 5 years.
Yeah. See, and that's interesting to me is that, we think juries are sort of the ultimate arbiters. And in some ways they are, but maybe not.
In the end, the judge reviews the sentence of the jury. In Virginia, what they do is the jury gives the sentence, the jury's dismissed, and then the judge can either review and change the sentence. He can't fully change the sentence. So if it's 5 years, it's 5 years, and he has to play within the 5 years. He can't give more than 5 years, and he can't give less than 5 years, but he can suspend any portion of the 5 years. So sometimes, especially in Virginia, they will say, here's what the jury's decided. We're going to come back in so many months and do a final sentencing date. Wow. And that's when you put together your sentencing guidelines. Yeah. There's a review of your history. There's a review of the charges. There's a review of the facts associated with it. The defense, the prosecution, and probation all run sentencing guidelines, and there are guidelines in each state and in federal courts.
Oh, see, I know those. We spent a lot of time on that chart last semester.
Yeah, so even with the jury recommendation, they'll review, okay, well, they've recommended 5 years, but according to the sentencing guidelines, they recommend 2. Yeah. So we're going to ask the judge for 5 years with all but 2 suspended because that's what the guidelines say. So there usually is another date, even after the jury trial, for sentencing, final sentencing.
Which is fun. And okay, we talked about it last time. So say I'm sentenced. Can I now appeal this?
Yes, but
it has to be a mistake, doesn't it? I knew
there are very limited options for appeal from circuit court. Yeah. District court, much easier in most states. Virginia, it's not automatic rate. In Maryland, it's different. But it's still easier than appealing from circuit court to the appeals courts.
Right, because now you're batting in the big leagues when you get up there.
There has to be some wrong that was done. Some kind of injustice, some kind of error of law by the judge. Yeah. It's not just, I want a new trial.
So that would be, say the judge, I don't know, there was a new law that I was convicted under or something like that, right? And the judge didn't know or didn't remember, and it reflected that in sort of how the trial played out. You appeal it to the appeals court. Yes. The appeals court goes, yes, this was a reversible error. You go back down and have a new trial.
Not necessarily.
Oh, really?
You could just have new sentencing.
Okay, depending on what it was.
Yeah, depending on what the error was, you could have an entirely new trial. Or they could say there was nothing wrong with the trial, but there was something wrong with sentencing. We had one in Newport News that was a firearm by felon. And there's a specific, one's a mandatory 3 years, one's a mandatory 5 years. And the judge decided for a 5 year, the jury came back with 3 years. Okay. And he did the 5 years thinking it was the mandatory 5 years. So he changed the jury sentence. Gotcha. And the appeals court said, no, it was 3 years. The jury said 3 years. They didn't mess up. You did.
New resentencing.
New sentencing, but not new trial.
So like a new trial, now I'm thinking. So that would be maybe evidence was allowed in or excluded that was, impactful. Correct. And that the appeals court is going to say, yes, we do think this evidence in or out would have affected the outcome of the trial.
Absolutely. Is it exculpatory? Is it evidence that is likely to show possible innocence? Yeah. Then that had to be turned over by the prosecution. If exculpatory evidence was not turned over, that's a likely appeal. If there was ineffective assistance of counsel, that's an appeal. That was the most common appeal that we got, was they're going to write a motion, a brief that says there's ineffective assistance of counsel, or, exculpatory evidence wasn't allowed. The judge did not take into consideration these things when he should have. But even though you write a request for an appeal, doesn't mean you're going to get.
Right.
It's very, very limited, the number of appeals cases that are actually accepted and heard by the appellate courts.
Okay, so now in Virginia...
Oh, goodness.
We're going to go all the way up. I'm just curious now.
We're going up.
Okay, so say the appeals court...
Virginia Court of Appeals, yeah.
Says, how do you get up to the Supreme Court in Virginia with a case like this?
Well,
would you say...
It depends, because usually the appellate court, the Virginia Court of Appeals, is for criminal matters.
Yeah.
Where the Supreme Court is more for
Okay, civil. That makes sense.
But you
get appeal the appeals court decision.
You get another bite in an apple for a lot of criminal cases where, let's say, an appeals decision is done. They agree with the court. Defense appeals to the Supreme Court of Virginia.
Okay, so that's what it would be, is that the appeals court says, nah, we think the trial court got it right. And you say, I still disagree with you.
Yes.
And so then that's when you're writing the brief and appealing.
But the Supreme Court doesn't have to take it. They don't have to hear it. They can say, no, we completely agree, or there's no reason for us to hear it based on the type of appeal that it is.
Right. Because they're looking at sort of, and this is why the record is so important, looking at the record before as opposed to, I know we talked about it, I think before, sort of a de novo look. That's not what's happening at this point.
It's for Virginia, it's de novo from district to circuit, where you get a whole brand new trial.
Yeah, fresh eyes.
As if the first one never happened. But that's not the same as once it's a circuit court level, once it's been heard by a judge or a jury for a felony or an appealed misdemeanor.
Yeah, which is why you have to have the mistake, right? That's the difference.
You have to have some type of mistake, some type of error that occurred at this level, at the trial court level is how they say it. To
reverse and remanded.
Get an appeal and get it accepted and get it heard.
Right, so that's what's happening. The appeals court is not retrying the case. They're like, yes, there was a mistake. Do it again.
What's in your state?
Yes.
How different is it in your state? Is possession of heroin a misdemeanor or a felony in your state? Let us know.
I'm still stuck on that. I think I'm going to have to mull that over for a while.
What's the sentence for 4 years in Maryland up to 10 years in Virginia? What's yours? Yeah. Tell us. We are absolutely interested. This is the type of thing we want to know as well as you. So check us out. Enjoy what you're seeing, what you're hearing. Please like and subscribe. Like we said, our dog is going to continue to yip on the meantime. Tell us if you like the dogs. They're going to kind of be part of it.
For sure.
And I'm Virginia Tehrani.
And I'm Chelsey Rogers.
We are part of Tehrani Law LLC, because you never need a lawyer
till you do.